All right, welcome in, ladies and gentlemen, to the first live stream episode of the Bull City Coordinators Duke Football Coverage Podcast. It has been a while, and I am back, and I did not expect to be back to discuss what we're talking about now. So if you have questions about Duke, Mensah, the contract, what is going to happen, what could happen, just let me know. I hope you guys enjoy my background here. There's some interesting stuff on the wall, and that stuff up above me came with the house. I don't know what it is. I didn't put it in there. But anyway, so I want to talk to you guys about this. It's a complicated situation, and at the outset, let me just say this, okay? Let me just say this. I am not here to take a side in favor of Duke, even though I am a Duke fan. Even though I've been to Duke football games, even though I have rooted against Miami in the national championship, right? And I'm not a huge Miami fan. The purpose of this podcast episode is to provide my legal analysis of this case and how I think it will play out. A couple of disclaimers. I'm an attorney. I practice law in Virginia. I don't know if it's ethical for me to advertise on here, so I'm not going to advertise on here. But what I am going to say is this. Pause as I take a quick sip of tea from my wonderful Caesar Was a Total Dirtbag mug, which you can get at our Tea Public store, by the way. Let me just say, my primary area of work is not contract law, okay? However, what I do is interpret statutes, and I have to read a bunch of releases and other documents. So reading and interpreting things is something that I do have a lot of familiarity with. I've been in practice in Virginia as a licensed attorney since 2008. When I get to this fall, I don't remember exactly when my law license was issued, fall, winter, it'll have been 18 years. So we're closing in on 2 decades, 2 full decades here, okay? Have a lot of experience. This is a new area of law in some respects for a lot of us out here, but it's not really that complex. You're just looking at simple contract law, common law concepts, common law rules when it comes to interpreting agreements, but also you're getting into the equitable powers of a court. What do I mean by equitable powers of a court? Before I do that, let me just say there are 2 types of powers that a court has. One is its legal power, so the ability to grant relief for money damages, monetary claims. Then there are dealing with non-monetary claims, okay? And what do I mean by that? What we're talking about right now, granting an injunction. That is something that comes from equity, an equitable power, okay? I know a little bit about injunctions. When I was at law school, I was fortunate enough to have been taught by the Virginia expert on injunctions and on equity, Doug Rendelman. He was a great professor at W&L. I learned a lot from him about remedies. I learned a lot from him about injunctions. Okay, so an equitable claim is when you're seeking generally non-monetary relief, which is what Duke is seeking here through the temporary restraining order. All right, hope everybody's with me so far. If you have questions, drop them into the chat, okay? And we'll go over all these, okay? I hope all this is working. I'm not seeing anything on the Twitter feed that is saying that there is a problem, all right? So let me go through kind of procedurally. Well, before we get into the procedure and the discussion of the case and the agreement and all that stuff. But what I want to say from the outset is I think Duke is going to win, however you define win, because as a lawyer friend of mine once told me, victory is all in how you define the parameters. And that's going to be important here because how you define the parameters could mean a win for Duke, could also mean a win for Darian Mensah, and potentially the University of Miami if all the reporting is accurate. Now, what I think will happen in this case is it will end up in arbitration, okay? It'll end up in arbitration, and Duke will get a lot of money from this. How much, I don't know, but Duke is going to get paid, okay? Why do I say that? Because this is a licensing agreement. We need to stop acting like this is brand new law, like this is something crazy, like something that we've never seen before. When courts do that, they issue terrible rulings, like all these sanctions opinions that have come down when lawyers use AI and AI cites hallucinated cases that don't exist, okay? There's already existing rules for courts on how to deal with it. You don't need new rules or new policies just because a new technology or new instance comes along. What you do is what my professor Josh Fairfield taught me, which is you take existing concepts and you apply the best fitting concepts to the situation. So, has a school sued a player to enforce a licensing agreement before? No. Are licensing agreements enforced all the time? Yes, of course they are. Stadium naming rights, franchisee agreements, all sorts of paid sponsorships. This is nothing new and this is nothing complicated. And we shouldn't act like it's really new or complicated. It's just the newest application of existing law. Okay? So there's nothing complicated about this. This is an enforceable agreement. It's a licensing agreement, not an employment agreement. It doesn't really matter that it's not an employment agreement, but we're just talking about the terms. I think Duke's going to win, and I think Duke's likely to get monetary damages at the end. The amount, I have no idea the amount. That's complicated, but that's going to go through arbitration, and all that's going to be kept fairly secret from us, okay? That's going to be kept fairly secret from us. That's how arbitration works, all right? So I'm just saying that at the outset. Now, let's go through a procedural recap here. But before we do that, we've got two questions. One says, we know that Duke is suing Mensah and they'll be in court on the 29th, but what are even the possible outcomes? Like what will happen on the 30th? Good question. I'll get to that at the end as far as what I think is going to happen. All right. But definitely arbitration will happen. Whether Duke is able to keep Mensah from going to another school, I'm not sure about that. Then we've got another one from DG Purds. If football players are classified as university employees, does that create a legal or ethical obligation to classify all student athletes the same way? How is this sustainable? That one's above my pay grade, but I do think that all of the employees, all the students, all the athletes should be made employees. We need to get rid of this legal fiction about them not being employees. If you look up any test for employment, control, the ability to control, all that's there. They're clearly employees. They're just not allowed to be called employees. It's stupid. It's insane. But no, I don't make the rules. I just work here. All right. So how did we get here? Well, we got here because Miami had been, and I'm going to say Miami based on what the reporting is. Could be a different school, but everybody's saying Miami. So that's what I'm going to go with here. Okay. Miami had been recruiting and trying to get another quarterback. That fell through. And then there was some contact between, again, likely Miami and Mensah and or his agents or representatives. All this is laid out. A lot of the timing on this is laid out in the complaint, which I have a copy of, and I'll refer to at times throughout this. That discussion and that communication resulted in Darian Mensah deciding to enter the transfer portal and asking to enter the transfer portal on the last day that players had to notify their schools of an intent to do so. Okay. And if you're wondering the timing on all this, what you want to do is look at the complaint that was filed, the verified complaint and application in motion for temporary and preliminary injunctive relief in aid of arbitration that was filed by Duke. The timing on this is set forth very clearly if you start at page 8 in paragraphs 30, continuing on the next page through 32, and then a little bit more in paragraph 34, okay? And then you can kind of skip ahead to Appendix A, which is the licensing agreement, which is what we all really care about, right? So then that led to, that was a Friday, January 16th, come the 19th, and thereafter, Duke files its motion, all right, its complaint, which I already mentioned. And then there was a hearing on the request for a temporary restraining order. Fun fact, I have handled requests for temporary restraining orders, representing people who wanted them and also representing people who were the subjects of restraining orders. So I've got some familiarity with this, all right? That type of restraining order that I was dealing with, those that I had, fundamentally different from this, but the general concepts are the same, okay? So there was some initial reporting that Duke had kind of lost that TRO hearing, but then when the actual reporting came out, all of it came out, Duke got about 80% of what it asked for, okay? So Mensah could not enroll at another school. He couldn't sign another licensing agreement. Arbitration was compelled, and he could not go play anywhere else until a full hearing on the merits could take place on February 2. All right. That's where we got. That's how we got where we are today. All right. That's a big win, and I want to tell you why it's a big win. If you look at, which I also have a copy of, if you look at paragraph 2, this is on page 6 of the entered order granting the temporary restraining order. I'm going to read it to you. This was a big win for Duke. It reads, for the duration of this order, comma, defendant Mensah and his agents, comma, employees, comma, I'll stop doing like I'm dictating this. I'm sorry. Attorneys, old habits die hard, and all persons acting in concert or participation with him with his knowledge or under his actual or apparent authority are enjoined from enrolling at another collegiate institution, playing football at another collegiate institution, licensing his NIL to another collegiate institution, taking any other action that would interfere with, diminish, or impair Duke University's exclusive rights under the contract, and otherwise committing any further breaches of the terms and conditions of this contract. However, he was allowed to enter the transfer portal. All right? That's a big win for Duke. Okay, so on Friday, as I'm coming back from a work-related trip, before I got in my truck, I checked my phone and saw some stuff was blowing up about Mensah filing a motion for reconsideration on an emergency basis. When I got back, I was able to read it. Before I started driving, I'd read some reporting about it. And I got to tell you, that is not something that I would have filed. I don't think that pleading did Mensah any favors. I think the timing of it was bad, one, and two, the contents of it were not good. And I'm going to tell you a little bit about what I mean by that here next. So the too long didn't read version of that motion is basically, I've already breached this licensing agreement a lot. Please let me out of it so I can complete the final breach and breach it again. That basically is what Mensah's attorneys filed and is in no way anything that I would have let get filed or put out there. Absolutely not. If I'd been his lawyer, I would not have filed that. Okay. Now, each attorney has a different reason for filing what he or she files. I'm just telling you my personal preference as far as what I would have done. I'm not commenting in any way on whether it was the right thing or the wrong thing to do. All right. Not doing that at all. All right. But here is why I would not have filed that. All right. Because essentially what happened when that got filed is that everything that Duke had alleged was established to be accurate, because it wasn't just a pleading. A pleading is not evidence. All right. But there's an affidavit from Darian Mensah in there. All right. That he signed that establishes everything Duke had been trying to establish as a reason that they needed injunctive relief and to force this into arbitration. And what do I mean by that? Okay. Well, let me tell you what I mean by that. Remember, what Duke had alleged in its complaint was that, if you look at paragraph 34, upon information and belief, Mensah or his family or his representatives, acting with his knowledge or with his actual or apparent authority, have breached the promises and agreements in the Mensah contract by, among other actions, disclosing its monetary terms, seeking to license his NIL in football and to another collegiate institution. I think it might be a type. Oh, in football and to another collegiate institution, seeking his enrollment at another institution, initiating contact with admissions or athletic staff at another institution, failing to notify Duke, and it goes on. Okay. That's essentially how Duke is saying Mensah committed his breaches of the licensing agreement. Okay. Because if you look at the licensing agreement here, and I'm scrolling ahead, so if I miss it here, what Mensah agreed to do, all right, this is in section 4. Without Duke's prior written approval, student athlete will not disclose any information about this license to any third party. There's some exceptions to that. All right. And on top of that, there is another section. Let me see if I can find it. This is section 7. Section 7 under representations and warranties, subsection 3. Student athlete, that means Mensah represents and warrants that A, student athlete has not previously made and after the effective date will not make any similar commitment, whether through execution of a letter of intent or otherwise, to enroll at or compete in athletics for another collegiate institution which student athlete has not lawfully revoked. All right. So you see what I mean there? It also goes into paragraph C. He will not initiate contact with admissions or athletic staffs at other institutions. Okay. That is what he agreed to do. And then if you look at what Duke's complaint reads, Duke is saying he did all these things he said he wouldn't do. If you look at his, excuse me, if you look at his affidavit, all right, what Mensah says is, in paragraph 9, after the hearing and as part of my efforts to comply with the temporary restraining order, an agent on my behalf communicated this restriction to other collegiate institutions who have indicated to me their interest in my enrollment in playing football. So he's saying basically, yes, I have been in communication through my agents, at least with other schools that want me to come play there, right? And he's also kind of saying that I violated the terms of the temporary restraining order. If you look at paragraph 2 of the relief, which we already read, he's saying, yeah, we had some communications after this order was entered that I may not have been allowed to have. I wouldn't have filed that. Okay. And then as you go on into paragraph 10, if you go back to the affidavit, after the hearing, I learned for the first time that enrollment deadlines at other collegiate institutions who have indicated to me their interest in my enrollment will expire on Friday, January 23, 2026. Paragraph 11 basically says he was not aware of those deadlines at any other prior time. And then if he misses the deadlines at other collegiate institutions, he could be permanently foreclosed from the opportunity to do so. Would not have filed that because he's basically saying I've done everything that I agreed not to as a result of this licensing agreement. So would not have done that. Not at all. So what does that mean? Well, it leads to a couple of problems for Mensah because immediately after this happened, there was some, and let me explain a little bit here about injunctions and injunctive relief. Injunctive relief is hard to get. It's a multi-factor test, but the main one is that there is no adequate remedy at law for, in this case, Duke. Okay, so an injunction has to be given to protect Duke from suffering irreparable harm. All right. If there's money damages that are available, you don't get an injunction. If there's not irreparable harm, you don't get an injunction. Here, though, I'm trying to think of a way to say this that's it's easy. What Mensah, when he filed this, okay, not long after he filed this, there was some immediate reporting coming out, okay, that Miami would just extend the deadline for him to enroll through some sort of a waiver process. I am telling you, his North Carolina counsel must have wanted to throw something against the wall when that happened, okay? Because that shows there's no reason not to extend this out if he can just enroll at any time because he's not going to suffer permanent harm, right? You know, what's the harm to Mensah if he'll just be able to enroll at a later date if we keep this temporary restraining order in place? So that undercuts completely that argument that he's just making, which is I can't get into a new school unless you give me the opportunity to enroll now, right? He's trying to say I'll miss out on this forever. Nope, apparently not. His North Carolina attorney must be furious. I know I would be, okay? The other reason that I wouldn't have filed that, though, and again, this goes back to the point, Duke can go in and say, look, we are going to suffer irreparable harm here because he's clearly been having these communications. He's been disclosing the terms of our agreement. All this information's been getting out that we had contracted to keep secret, okay? And while he gets to go to another place, we can't get a quarterback of similar replacement value or somebody with, they'll have to say, somebody with similar marketable name, image, and likeness rights. Okay? Because if you look at who's available in the portal, there's nobody with the same stat line that Mensah has, right? So Duke has a good argument about irreparable harm here. The complicated part about that is, and I think the timing of it in the portal, too, of when he went in, helps Duke establish irreparable harm. And Cooper Barcate, apparently being tied to Miami and also going into the portal, further establishes irreparable harm that Duke has suffered, because you can't go and replace Cooper Barcate, right? Queso already left, remember? How are you going to replace this guy? Got another question. Can his, quote, skill, end quote, be used in the irreparable harm argument? I thought that wasn't factored. I think you can, actually, and if I were Duke, I would make that argument. It's just say there's nobody in the portal, nobody we can get with a comparable name, image, and likeness rights. That's what I would argue, and that's what I would say. Now, you got to be careful because you don't want to dog any of these other quarterbacks that you're bringing in, right? But you can also say that there are people who have eligibility questions. That's kind of the way that you might want to approach it. So you're not even sure you'll be able to get their NIL rights. Okay. All right. So now the next thing that I wanted to get at, and I got a little distracted here. I should have been taking notes as I was doing this. Let's go back though to whether Duke's able to get an injunction to keep him from enrolling Mensah elsewhere. And that's going to be a little bit of a challenge, I think, because I can see a judge struggling with saying, you're telling me I have to make this guy not continue his educational career. That could be a hard pill for a judge to swallow, but I think Duke gets around that by saying, look at this reporting from Miami. He's going to be able to enroll whenever. What does it matter? Right? But I also think one of the big challenges is going to be for the judge saying, well, look, can't you just get money damages from this? Can't they just write you a check for some amount? I mean, and then the judge is going to ask the Duke lawyers, he's going to turn to the licensing agreement, and he's going to turn to page 6 of the licensing agreement. And it is section 6.2, okay? It says, look, you kind of drawn this out and listed that the total liability of either party for claims arising out of or in connection with this license, including for breach of contract, won't exceed the total value of all consideration provided by Duke to student athlete under this license. So you've kind of set a monetary factor here, right? For what you will get in return, or what you will get if there's a breach. So why do I need to give you an injunction beyond ordering you to arbitration as the contract calls for, which will happen. That's going to happen. I'm confident of that. Now, judges can always do things that aren't expected. So I'm telling you, there's a chance it won't go to arbitration, but looking at it, I feel kind of confident it will go to arbitration. So the damages are the fact that there's monetary damages, though, do weigh against being able to get an injunction on all these other elements. I do think, though, there probably will be some permanent injunction issued on the confidentiality portion of the agreement. And there is one thing that I did want to say here about the damages. I'm not an attorney who's licensed in North Carolina. I am licensed in Virginia. But there was a lot of talk about how the most that Duke could be liable or Mensah could be liable to Duke for under this agreement is the amount that Duke has paid him under the licensing agreement. But if you look at section 6.3, it says the foregoing limitations in section 6.2, which is what I just read to you all, okay, shall not apply to claims, damages, or losses relating to a party's indemnification obligations under this license, or B, a party's failure to comply with its confidentiality obligations under this license. That's a little bit of a bigger amount of damages. And then you got to go back to section 4 as far as what Mensah promised to keep quiet. Okay. So what I'm saying here is that portion of it does cut against Duke's argument about the need for an injunction on all of these counts. So I've been going for about 25 minutes now, okay, talking about the contract, what it means, how we break it down, what it says, okay? So here is what I want to big picture conclude with. All right, is this. This is an enforceable license agreement, okay? A court is most likely to find that this agreement is enforceable and to order arbitration. Could be wrong about that. Things that you don't expect do happen, okay, from time to time. But that's what I think is the most likely outcome, okay? So the proceeding between Mensah and Duke will go to arbitration, all right? And there's nothing abnormal about Duke filing a lawsuit to compel arbitration. Happens all the time, okay? What happens in arbitration, there's going to be some discovery, which could build a case against Mensah for this breach of the confidentiality provision and others. Apparently, there's some North Carolina law about Unfair Trade Practices Act. I'm not an expert on that. I'm not going to comment on it. I understand that it's there. There are other lawyers in North Carolina. David McKenzie is one who has talked about it. I think Lee Rodeo may have talked about it some. Those guys are who you should go ask questions about for that provision of law. All right. But remember, Duke, under this agreement, until the agreement is voided or comes to its end, has all of Mensah's NIL rights. So if Mensah goes to Miami and this agreement is upheld, most of it anyway, it's possible that the money that Mensah could get from Miami would have to go to Duke. Possible. Okay, we'll see. Depends on what the arbitrator awards. All right. On top of that, so again, where are we? Duke most likely has an enforceable licensing agreement, likely go to arbitration. I think that would certainly result in Duke saying, we get all your NIL money that you would get from Miami, and Miami can't even use your NIL money, use your NIL rights unless we come to a negotiated resolution. And I think that that's what probably will happen unless Duke really, really sticks to its guns here and says, no, you did this too late in the game. You did it too late for us to acquire a quarterback of a similar replacement value. And because of that, we're going to stick you with this licensing agreement that you signed. Remember, you signed a 2-year agreement. Okay. So I think Duke is likely to win on all key points. The challenging point's going to be, is Duke going to be able to win, okay, on the one issue that matters, which is keeping him at Duke or keeping him from enrolling elsewhere? I think that might be a hard pill for a judge to swallow. It wouldn't surprise me if we see on January 29th the judge say, okay, I'm going to let you go to another school. But it's also possible that a judge could say, well, look, all this reporting says you've got you can enroll late. And on top of that, you've already told me that you've had people communicating with other schools. A, who are the other schools? And B, what have you been told? That's the first question that I'm going to ask as a judge. And that would not be something that I would want my client to have to answer. So that could be a little bit uncomfortable. All right. Well, and the reason is because it establishes potential breaches and strengthens Duke's claim. Now, got a couple other questions. Wow. So Duke could get more than $4 million. Would Miami help Mensah pay for that? I assume so. And you also asked what section of the contract that was. You want to go back to the licensing agreement on page 7. It's on page 6. Excuse me, section 7.3. That's what you want to look at. Another question. Duke paid a premium for Mensah. Does the ACC championship win increase the damages? Depends on how you want to argue that. That's a good question. The challenge with arguing that is then you get to a little bit more into his performance on the field, which this agreement is not tied to his performance on the field. But I think what you can say is there are just no people with similar NIL rights and marketability uh, uh, marketability potential out there. It's just not there. So we can't do it, right? We can't secure a replacement value. So that's going to be an interesting thing to see how that plays out. I hope that answers your question. All right. Now, let me see if we got any questions on Twitter. Being told visual and sound is great. Good. So I think to conclude where we're going to end up in this, enforceable licensing agreement will go to arbitration. Damages TBD. Judge may get a little squirrely with keeping all of the temporary restraining order in place. Look, it's easy to get a temporary order. It's hard to get a permanent one. I can tell you that from experience. All right. We'll go to arbitration. Mensah, as far as whether he ends up somewhere else or not, I have no idea. What Duke's position is, I've not communicated with any of the lawyers or anybody from the athletic department, and I have not tried to. And I'm not really interested in doing that. I don't have enough time for that. But I hope that this discussion has provided some explanation and clarity regarding what to expect from this agreement. There's nothing groundbreaking about this. It is an agreement just like any other. It is likely to be enforced. It was negotiated at arm's length. Although I don't think we're going to see too many more 2-year NIL licensing agreements like we saw right here. I think this is going to be a thing of the past. Okay. And you got to keep in mind that these cases are marathons. They're not sprints. They go in peaks and valleys, and they go in fits and starts. So you might take, if you're a Duke fan and you want Duke to win, Duke may take a couple steps forward, then a couple steps back, then a couple steps forward, a couple steps back, till the case concludes. Same thing, by the way, with Miami. You may see some victory on the 29th, but not a total victory. You saw some victory at the first hearing for Duke, not a total victory. Some victory for Mensah, not a total victory, right? It's equity. It's balancing things, right? It's a balancing test. But this is nothing new. What we're looking at isn't new. It's been done before. All this has been done before. You just have to take existing legal precedent, existing legal rules, and apply them to this situation. Okay, so I hope that makes some sense. Now, I've been doing this for over half an hour. I'm going to close out here on a couple of questions. We got another one. Is it a possibility through arbitration that he goes to Miami, signs NIL deals, and Duke can settle a percentage to receive monetary settlement through it? 100%. I should have mentioned that. Thank you for asking that question. I appreciate it. Settlement can happen at any time, on any grounds, for any reason that the parties agree to. It would not surprise me if they enter into a settlement. And then Mensah goes to Miami, and a lot of money comes to Duke. Okay. I did think it was interesting, though, that you started to see Cristobal's name in connection with an NFL job, which made me think for a minute he's not too confident that he's going to get Mensah and Barcade. I don't know. All right, another question. Is there a chance a judge says Mensah can enroll elsewhere but prevent him from entering any athletic program? Absolutely, 100%. That could happen. Judges have a lot of discretion in equitable proceedings, but that discretion is not absolute, like cases are supposed to be decided alike. So, yes, that totally could happen. In terms of the contract, though, I would think if you let him go to another school, you're probably going to let him enroll to play somewhere. But again, this licensing agreement's pretty strong. And there's stuff from Heitner on Twitter about how this was collaborative. Again, if you're a lawyer, don't talk about your client, what you've done on Twitter. You're just asking for problems. You know, remember, real G's move in silence, okay? Again, not saying that was the wrong thing for Heitner to do at all. Everybody has their own different opinion and their own different approach, but I personally would not do that. Not saying it's the wrong thing to do, but I would tell people that I work with, don't comment on that stuff, okay? And I'll go ahead and see if I can pull up what that actual tweet was that he talked about here. And I'm going to stall for time, which is, I know, boring and not fun, and I apologize for that. I should have been a little bit more prepared, but I got here. I didn't intend to get into this today. Let me see if I can find it real quick. Now, this might take too long. Man, I didn't remember him posting this much, but I don't really follow him. So anyway, but he just I think you got it. Oh, here it is. This is January 1. Working with Darian Mensah's agents at YMAPAA, that's Yankee Mike Alpha Papa Alpha Alpha, we reached a mutually beneficial 2-year agreement with Duke in 2024. The negotiation was collaborative and constructive, the right approach to deal making built on cooperation rather than conflict, and now reigning ACC champs. I personally would not have posted that, but everybody's does things differently. So anyway, I hope this was helpful. Enforceable agreement, likely to go to arbitration. Duke likely to get a bag at the end of the day, right? Question's going to be, where does Mensah end up? And does he stay in Durham? Does he stay in Miami? I have no idea on that, but I think it's most likely that he doesn't, but Duke seems to be digging in his heels. So we'll see what happens in the arbitration. If this had happened earlier in the portal cycle, could be different. Duke has to try to mitigate or lessen its damages, and it has to go out there and try to get a replacement player. So we'll see what happens. But anyway, I hope this was helpful. If you have any other questions, you know where to find me. I'm on most of the socials, either at Duke FB coverage or at Antiquity Pod. You can go to my website, it's classicalantiquitypod.com or bullcitycoordinators.com. You can find me on Twitter. You can call the podcast. It's been a while since I've had to shout out this number, so give me 1 second here, guys. Call the podcast, leave a message, 540-632-0160. Hope you learned something. You know a little bit more about law. You're a little more prepared. You can go out there, kick you-know-what, chew bubble gum. Let me get the quote right. You can go out there, chew bubble gum, and kick ass. And you're all out of bubble gum. All right, guys, I'll see you.